The next case is Exec Properties LLC versus Discovery Oil and Gas LLC. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your arguments, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments if that applies here. You should refer to them by initials or terms like the child. We have read your briefs and are prepared to proceed when you are.
Thank you, Your Honor. Larry Shenives on behalf of the appellant, Exec Properties. I'm going to address, I guess, the elephant in the room for this whole case, and that's whether or not the fact that my client accepted $12,500 during the pendency of the proceedings that makes the case moot. I say it does not, because simply this was an issue of not a judgment, first of all. This was supposedly an agreed amount of money, and there was in disagreement of that. At the time of hearings, my client testified that he believed he was owed at least $30,000. And he said he wanted that full amount, is what he told his attorney. So there was no accord and satisfaction here, because if anything, as I stated in my brief, the brief was written by appellee's counsel, that they reserved, or they put in a paragraph that would allow them to have an offset if the court had ruled in appellant's favor. So they are not in any way, had my client accepted that, quote, dollar amount as a full satisfaction of the
Let me ask you a question I was unclear about factually when I looked at the record. The $12,500 came in a check, it was cash. That an escrow somewhere has been released to your client. Is there any reservation of rights made when the check came in?
My understanding is there was a reservation, but I haven't seen a copy of the canceled check.
And is the check in your or someone's escrow account as we sit here?
I'm sorry, Your Honor?
Is the check in someone's escrow account as we sit here, or has been released out to your client? If you know, you don't know, you don't know.
I can't
Or
answer.
just, like, or more importantly, what does the record say? I can't see in the record that that question has been answered about where the money went. I can see a check was cashed. I don't see anything in the record that tells me in an escrow account here, given to your client, or where it is.
I understand that. All I can testify, but not testify to, state is I handed the checks to my client.
Okay.
And at that point in time, they hadn't been negotiated. At the time of the hearing, they had not been negotiated. That I know.
Okay. At the hearing in front of Judge McCarty, they had not been negotiated.
That's correct.
So sometime after that, they may have been negotiated to the extent that appellee is saying now it's moot because they've been negotiated.
That is correct.
Which answers my question as to why it wasn't raised at the hearing in front of Judge McCarty about this. They've been accorded satisfaction, it hadn't happened yet. Okay.
Isn't there more to this appeal?
Why did we raise the issue, you say?
Well, I was curious as to why at the hearing before Judge McCarty, appellees didn't say, oh, and by the way, we've given them $12,500 and they've got the checks and they have it.
Well, at that point in time,
They
the checks had not even been negotiated.
Understood.
So basically, at that, as far as that issue goes, but my client did testify specifically that he disagreed with the dollar amount. It's on the record. He said he was owed $30,000. So again, I say no, it doesn't terminate the case or terminate the appeal.
Well, aren't there other?
I'm sorry, go ahead.
Aren't there other parts of this appeal besides the dollar amount? Didn't the judge's orders basically say one of the provisions of the agreement was?
Oh, that basically the trial court said was this $12,500 takes care of any outstanding claim.
Right, without a-
And at that time, the only outstanding claim was the appellant's motion that had already been filed to enforce the original settlement agreement. So the other, and also we argued that it was entered into between counsel. There's no dispute. My client didn't see, quote, the written copy of this agreement until 2 days after they supposedly entered into the oral agreement, and he never signed it. He immediately rejected it. He testified at hearing why he rejected it. The issue was raised that, well, we didn't raise that in our initial brief, and it's true, we didn't. I was not the original counsel on this case. I took over. I barely had any time to prepare and get back the documents and review things before the motion was filed against us to enforce the amended settlement agreement. So we did raise the issue specifically at hearing, that counsel did not have that authority to enter into that agreement. The appellant testified that the retainer agreement did not provide for counsel to enter to a settlement agreement. The other issue, and this is not just about money. If this court says, okay, $12,500 settled those outstanding claims that the plaintiff had, or I'm sorry, now appellant, had at that time on the original enforcement or settlement agreement, that's fine. The issue really here is, and I've stressed it, is that paragraph 4 in the amended settlement agreement, I'm sorry, that basically wipes out the lease. Any obligations of the appellee under the lease are supposedly gone. But again, then the court said we had to agree on that language, and there's never been any agreement. So,
Would that mean the case isn't final then?
I'm sorry?
Would that mean the decision from the trial court isn't final, and it should be remanded for the trial court to
well,
determine what
the trial
paragraph 4
court,
means?
I'm sorry, Your Honor, I didn't.
What it should be remanded for the trial court to figure out what paragraph 4 means.
That was going to be, as I close here. Yes, because simply, it's the trial court found that irrelevant, or not a material term, or not an essential term. How can something that totally, basically voids the lease, the obligations of the lease, as far as producing, having the well ready to produce, which it isn't after 6 years or 5 years, whatever the exact amount of time is, eliminating all that, how can that not be an essential term? That's an issue. So again, if the court wants to accept the argument that this appeal should be moot, it still doesn't resolve that issue out there of that paragraph. The court specifically did not rule on it. It just says the parties got to agree. We haven't agreed. I mean, because obviously what it does is detrimental to my client versus what it does, beneficial to, colleague. So, based on that, those factors, and the other issue I'll touch on is simply that the trial court allowed counsel, appellee's counsel, Mr. Funk, to testify to, specifically his conversations with the other counsel, as to, well, we had an agreement, this, that. That's hearsay. I mean, there was no admissions involved. I think they argued in their brief that they were admissions on the part of appellant's then counsel. And I say, no, they weren't any kind of admissions. So, based on that, we're going to ask, and I don't think I reserved any time, did I, Your Honor? Do I have any time left?
If you stop now, you'll have your full 5 minutes. You have about 7 minutes left.
Okay. I'll go ahead and stop then. Thank you, Your Honor.
A full 5 minutes on rebuttal.
May it please the court, Stephen Funk, Representative Andrews, on behalf of the appellees, Discovery Oil and Gas LLC and Discovery Energy Resources LLC. Let me start off with the mootness point. I do think that there is no factual dispute that they cashed the checks, and it's attached to the affidavit that we submitted in support of our motion to dismiss. Generally, mootness is going to be a fact that occurs after the appeal, so it's presented pursuant to.
And that thing, I was wondering why, when I read through the record, when that occurred and why it wasn't raised in front of Judge McCarty. That's because the checks had not been cashed then, but seem to have been cashed now at this point.
In the record, though, relating to those checks that were tendered, there was evidence that we tendered those checks and
Right.
specifically stated when we tendered them that they were only for the payment of the First Amendment of the settlement agreement. In other words, it was not, a credit towards future payments or anything like that. It was very, very explicit. And so that is part of the testimony in the record. And in fact, at that point, I think I testified that, to my knowledge, you haven't cashed those at this point. You're still holding them.
But can you really make a mootness argument when the settlement was structured to receive payments?
Well, Your
When you-
Honor,
When you break it up, obviously you're not gonna hold on to each payment until the whole matter is resolved.
no, the settlement provided for a $12,500 payment to be made in 2 installments. So the paragraph that he cites to, actually, all that paragraph says is that if, for example, we didn't make the second payment, then he'd have the right to revive his motion to enforce the settlement agreement, and that first payment would be deemed as a credit.
So if there was a dispute about the total amount, would it couldn't be made in the third payment?
No, that's not, the agreement was that 12,500, and this is what this actually, a settlement is very simple. It was simply $12,500 in exchange for a complete release of all outstanding claims. That is what any settlement does.
Right,
Payment
that's
money
your,
in exchange
that's
for
your
release.
assertion of what the settlement was, right? So-
Well, that's what the trial court found the settlement to be. That would be subject to a manifest way of the evidence standard of review. The trial court found that there was in fact a settlement, and this court has held that a settlement can arise once a party accepts a settlement offer, right? And so the fact that somebody refuses to sign the agreement later doesn't mean that there wasn't a settlement. Trial court found, based upon the evidence, that there was a settlement, which agreement of $12,500 in exchange for the payment of claims. That is the issue on appeal. Was there in fact a settlement? What the case law would say is, and we cite them, the Etienne case, the Sturgill case, the Horman case, where a party voluntarily accepts the amount owed under the settlement, the full amount of the settlement, that moves the appeal. And that's based upon Supreme Court's decision in Blodgett versus Blodgett, where
But isn't that dicier when the issue on appeal is what is the settlement?
that's the whole point, Your Honor. They're challenging the validity of the settlement. When somebody voluntarily accepts the amounts owed under the settlement, they forfeit their right to challenge the validity of the settlement. That's what those cases hold.
So if they would have received one payment and cashed it, and then there was a dispute about that one payment being the one payment, it would be moot at this point?
No, I think it's the full amount of the settlement. So they accepted the $12,500 that was tendered based upon the
But
settlement.
let's say that you argued, just hypothetically, that 6,000 was the full amount. And they're saying, no, it was payments.
Well,
And you say, well, the court ruled that it's 6,000, so therefore it's paid in total and it's moot.
let me try to backstep in a second. The trial court found that the settlement was $12,500. Okay, when they pay $12,500, that's they're satisfying that settlement agreement. What the courts have said is that that voluntary payment of the settlement, the full amount of settlement, forfeits the right on appeal to challenge the validity of the settlement, because you voluntarily executed the judgment, essentially, that has been upheld by the trial court. And we cite 3 cases in our brief in which they involve settlements, in which the parties specifically are challenging the validity of the settlement. The court dismisses the appeal on mootness grounds because they voluntarily accepted the settlement check, the full amount of settlement check. They don't cite a single case in their briefs. Yes, sir.
And I follow your argument to that point, and I get what you're saying, and I get Judge McCarty's decision to that point, the trial court decision. Where I'm lost is this paragraph 4 language where this isn't material, but you guys gotta go settle. It sounds to me like, at that point, we've yet to figure out exactly what the settlement agreement is, which makes me feel to me like it's not final, there's more work for the trial court to do.
Or
Yeah,
or
and I don't-
potentially more money owed as well from that.
No, the full amount of money owed is $12,500. That's what the court held. That was the settlement. The settlement was, I'll pay you $12,500 in exchange for a full release of all liability. What the trial court, to answer your question, what the trial court found was that that was the material terms of the settlement. That's an enforceable settlement. Paragraph 4 was language that was added later as part of the negotiation.
Right, who's gonna build stuff where, and who's gonna put this here, and although I think, if I understand Tom's argument, it's that part of that language, you wanna say, it just said, if we don't pay the second part of the $12,500 in time, you can owe more money. they want to say, no, we still were able to collect this 5,000. I think if I understand from the first agreement that went on, if the thing wasn't hooked up properly, but be that as it may, I'm just looking at this as the court saying, hey, there's something else here that isn't resolved yet. You have to figure out what it is. How do I say it's final? She can deal with the trial court, deal with that mess, but how do I know it's final?
So there are two answers to your question.
Okay.
And first one is that I think there's a confusion of the paragraphs. Paragraph 4 only deals with the oil and gas, putting in the finishing equipment. Paragraph 2 is, I think it's paragraph 2, but it's totally separate about the $12,500 is being paid in 2 installments. If we don't pay by January 31st, then you have the right to enforce your agreement. If we make both those payments by January 31st, and there's no dispute that we did, then there's a full release and there's no further enforcement of the settlement agreement. And the release is specifically a release of the claims under the original settlement agreement and any other claims arising before January 31st, 2024. So let me get to your question about paragraph 4. What the trial court said about paragraph 4 is the material terms of the settlement are everything, the full release in exchange for outstanding claims. I'm not going to enforce paragraph 4 of the settlement agreement. That was a disputed term, and so therefore, unless the parties agree to that, I'm not enforcing that. So the judgment was final because what she did enforce is the terms, the material terms of the settlement that was released that was entered into on November 28th, 2023.
So what
$12,500.
would, assuming for the moment this work still hadn't been done, I don't have or hasn't, and I don't think the record tells me that one way or the other. Assuming someone had a dispute about the work being done, would they now have to file another action with the court to say, court determine what paragraph 4 is supposed to be, or they just left to twist in the wind forever about what 4 means if they don't agree?
Well, paragraph 4 dealt with ownership of the line, not whether the work was done. So
I thought some of it had to do with, and I could be wrong, because I looked at a number of the drafts.
yeah.
This connection will be at this location, and, you know, next to building A or E or east of this.
No, that might be that might be the original settlement agreement, not the First Amendment.
What do you think paragraph 4 said?
So paragraph 4 dealt with the ownership of the line between the building and the well. That's all it says. It was just clarifying that the ownership would be the property owners. That's why it was not a material term of the settlement, because it was just clarifying existing law. What was
Why do they have to agree on it? I mean, if it's clear
don't have
that's
to
what it
agree.
is, why did the court say you guys have to agree on it? Why did the court just say it's clear, ownership vests in whoever?
Because
and it's done.
Because there was a dispute on the language of that agreement. So the court said, well, that's not a material term of the settlement. The settlement is $12,500 in exchange for release of all outstanding claims. Paragraph 4 is then therefore not part of the settlement agreement, and therefore, unless the parties agree on that, I'm not enforcing that term.
So you understand why I feel some inherent inconsistency when you say, gee whiz, paragraph 4, which is included in the settlement agreement, isn't part of the settlement agreement.
But
I get what you're saying, that the lion's share of the concern was 12,500 resolves the case.
yeah,
But that's not what was the entirety of the settlement agreement.
but the judge, Your Honor, the trial court has the authority to determine what the terms of the settlement were. What the testimony shows is that on November 28th of 2023, the agreement was $12,500 in exchange for release of all outstanding claims. The language relating to paragraph 4 was added later, and there was no meeting of the minds on that final set of language.
That language was going back and forth on amendments at the same time. Well, to be fair, I don't know that there ever was an amendment on the 12,500 being owed.
So,
Right, that was in the initial agreement, and I don't think the agreements that go back and forth ever say, hey, let's make it 14,000 and 12,500. The amendments that went back and forth between you and prior counsel all seem to be paragraph 4 related, basically, and some grammatical corrections that were in.
That's right. So what the court, yeah, I'm sorry.
I'm sorry, go ahead and answer that.
I just want to say
So
that.
go ahead.
So the point is that the trial court determined first that there was a settlement because they accepted the settlement offer. 2, that the terms of the settlement were $12,500 in exchange for a full release of outstanding claims. That release included a release of the obligations under the settlement agreement. Any breach of the settlement agreement, which was the subject of the claim. Did you build this additional items? That was released in exchange for the $12,500. That was the whole point of the settlement. What she found was that material paragraph 4 was not a material term of the settlement, so therefore it did not preclude the enforcement of the settlement agreement. And so all she's saying there at the last sentence of the order is that if you want paragraph 4, you're going to have to agree on that. Otherwise, it's not part of the settlement. I'm sorry. Go ahead.
I have a jurisdictional question because it sounds like you had a settlement agreement at the onset and the court retained jurisdiction over that settlement agreement, but it sounds like things have changed.
Well-
You were calling it an amendment, but it sounds to me like a new agreement.
Wait.
And then the question is, which one is the court enforcing, the original settlement or the new settlement, which the court may not have jurisdiction over if it is truly a new settlement?
So it's all part of the issue before the court was whether to enforce the original settlement agreement. That was what the court retained jurisdiction to do. What happens then is we have a hearing scheduled on whether to enforce the original settlement agreement. The parties entered into an amendment that says, okay, we don't want to have a hearing, we're going to settle it where you paid $12,500 in exchange for a full release of all liability under the original settlement agreement. The court is enforcing the settlement because it's all part of the dispute before the court. The dispute before the court is, did we breach the original settlement agreement? When we entered into a settlement that said, okay, you're going to release that claim in exchange for you paying $12,500, that's still relating to the dispute that was before the court.
So you had a settlement of the settlement agreement?
Yeah, essentially. And that happens all the time, right? So you come in with a motion to enforce a settlement agreement. Now, can we reach a resolution of that dispute? And that's what we did.
So the actual hearing was over the settlement of the settlement agreement?
The dispute was over, the underlying dispute was the enforcement of the settlement agreement. The issue before the court was that released in exchange for a payment of $12,500? And that's what the court found, was that it was released in exchange for $12,500. And what the case law would say is that where you're challenging the validity of that judgment on appeal, and you accept $12,500, the full amount of the settlement, then you forfeited your right to challenge that settlement on appeal. And they don't cite a single case in their brief on that issue. Now, their sole argument at the lower court hearing related to that the client didn't authorize a settlement agreement. But we cited, the trial court cited it, and we cited it in our briefs. There's a whole host of case law that says that when you authorize your client to enter into settlement negotiations, and then they settle the case, you're bound by that. And we cite to 9 cases, I'm sorry, anything you want to ask me? They cite to 9, we cite to 9 cases that cite that principle of law, including the Ohio Supreme Court, and they don't cite to any cases. They rely on cases based upon that a general retainer doesn't grant you the authority. But we're not relying on the general retainer. We're relying on his testimony that he authorized the client, his attorney, to enter into settlement negotiations. And so the trial court was correct to cite that case law in her order. And I think that, if you look at it, I think we cited 9 cases that stand for that proposition of law. And so it really comes down to, did he in fact authorize his client to enter into settlement negotiations? That's a factual issue. There was testimony to support that factual finding. They don't argue manifest way to the evidence in their brief, and in fact in their reply brief, they do concede that he authorized him to enter into settlement negotiations. So I think that's the main argument on appeal. And with respect to paragraph 4, that's also a manifest way to the evidence standard, because the trial court found that it was not a material term of the settlement. There was evidence to support that, because the purpose of paragraph 4 was to clarify the ownership language, and the court found that that was not a material term, so therefore that would be, if in order to reverse that, it would have to find that that was against the manifest way of the evidence. And so for all those reasons, and then in terms of the additional argument that they make, the hearsay, I think they don't understand what an admission is. An admission is a statement of a party opponent, and under 801D2, a statement of a party's attorney is an admission. And so that's why that was not hearsay. In fact, there's case law we cite in the brief that supports that proposition of law. So we asked the court to, unless there's any further questions, I'd ask the court to determine if this is moot. There's case law that we cite that's directly on point where a party voluntarily accepts a settlement, they waive their right to challenge that settlement on appeal. Two, if court does not find it's moot, then it should overrule the assignment of error and affirm the judgment. Thank you.
You have a full 5 minutes for rebuttal.
I don't think I'll need to, thank you. I gotta go to paragraph 4, I'm sorry. Paragraph 4 contains language that basically they were in this, not only in the original lease, but the first settlement agreement. They were required to get this well into producing status and also show that they had proof from the ODNR of the right to go ahead and produce, and that it was producing. That never happened, okay? Now, the language in paragraph 4 is saying that those dates are now eliminated. They're satisfied. So how do I go back now that he's another 12 months behind, hasn't paid any royalties, hasn't paid any penalties? How do I go back and say, I'm going to file a lawsuit on that? Because the court has eliminated, or the paragraph 4 has eliminated that, but then counsel just stated that paragraph 4 isn't there. It doesn't apply. So that's a little bit confusing to me, but I still think the matter needs to be remanded to the trial court on that issue of paragraph 4. What is it? It's more than just simply the equipment, the gas lines, as Your Honor said, gas lines go here, or this or that, or, no, it's far more than that. It's eliminating my client's right to enforce the settlement, the original lease, and the settlement agreement as to dates certain that this stuff was supposed to be done. The well was in producing status. Hell, the well was actually producing. The well had received approval for turn-on from ODNR. Those dates have been eliminated by paragraph 4. So,
Have they though, if it's a global resolution for everything from the past, if it's a settlement of a settlement?
well, again, what I said right up front, Your Honor,
Wouldn't you
is
still
the
have
only
rights
issue was,
from that point forward?
I'm sorry,
Wouldn't you still have rights from the time of the settlement for any other things?
not the way paragraph 4 is written, because it says those, when you go, it refers back to the first settlement agreement where new dates were set and said all those dates were satisfied. So they're saying, okay, even though it's not truly working, we've satisfied that date. And you can't sue us anymore on that date because you're saying it's done. And no way are we saying it's done. Okay, just the opposite. It's a not operating well to this date. And we want to be able to move forward on what the lease says and what the first settlement agreement said as far as times. Those should not be eliminated. The only issue should be, eliminated is our original, if the court finds in favor of appellee, our original claims at the time we filed was $15,000, or other counsel filed, they were in arrears. By the time of hearing, they were in arrears $30,000, okay? That $12,500, if the court wants to, can say, okay, that satisfies that issue. But that's all it satisfied, was our claim based on that. That's the outstanding claim that was out there. So based on that, we're going to ask the court to remand the matter, not only on the fact of what I've just mentioned on paragraph 4, but the fact that there was not a valid settlement agreement, the fact that my client never signed that agreement, that he saw it 2 days after supposedly was raised, and what counsel mentioned about you're not just relying on a general retainer, you're relying on counsel's testimony. Well, that's hearsay. For him to say, my client told me I can, it's actually double hearsay. For my client to tell me I can settle this, then for Mr. Funk to testify in court, I was told by Mr., I can't say John's last name, that's counsel, that I had approval to do it. That's double hearsay. So we'd ask the court to remand and reverse on those factors. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the opinion when it's filed, and the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentation.